This is Frontline on Air. Major stories on the go.
The steady immiseration of labour. By the end of the 1990s, both capital and a willing state had eviscerated the labour movement. The death blow will be dealt in the 2020s. Sudha Bharadwaj.
Voice by Rakesh Sharma, Timber Media.
The 1990s marked a watershed in the attitude of the Indian state towards labour, with the ushering in of liberalisation, privatisation and globalisation, LPG, policies. The early years of the LPG era saw sensational murders of trade unionists. The theatre activist Safdar Hashmi and members of his troupe, Jananatya Manch, were brutally attacked with iron rods by the henchmen of a Congress corporator as they performed a street play that campaigned for minimum wages in Jhandapur village in Sahibabad industrial area on January 1st, 1989. A worker named Ram Bahadur died on the spot. Hashmi succumbed to his injuries the next day. On January 4th, 1989, thousands of workers, students and artists watched the electrifying sight of a grieving Jananatya Manch led by Hashmi's partner Molayashri return to perform the unfinished play at the same spot. In the early hours of September 28, 1991, Shankar Guha Niyogi, a legendary organizer of contract workers in Chhattisgarh, was shot and killed while asleep in his home in Bhilai. Niyogi, a Marxist-Leninist, founded the Chhattisgarh Mukti Morcha, an umbrella organization of workers and peasants centered at the Dalli Rajhara mines in Chhattisgarh. His union set up schools, a hospital, a cultural troupe and a football team and led a massive anti-alcohol movement among the workers. Niyogi left behind a tape-recorded statement that industrialists of the Simplex and Kedia groups and the Inspector General of Police of the BJP state government had hatched a conspiracy to kill him. On January 16, 1997, Dr. Datta Samant, a charismatic leader of the Bombay textile mill strike, was assassinated as he left his house in Powai, Mumbai. By then, around 65 textile mills had shut down and over 2.5 lakh workers had been displaced. The killing was said to have been prompted by the lockout of premier automobiles, the issue of mill lands and trade union rivalry, particularly with the Shiv Sena. It was only in 2023, 26 years later, that the gangster Chota Rajan was acquitted of the charge of Samant's murder. In the 1990s, what little was left of the honeymoon between capital and labour in post-colonial India thus came to a bloody end. The perils of contractualization. The Contract Labour Regulation and Abolition Act 1970 was a unique piece of Indian labour legislation that saw contractualization for what it was: an exploitative tool to deprive workers of the benefits accruing to regular employees. It prohibited the use of contract labour in necessary, regular and perennial work of any establishment. The story of how the law was systematically sabotaged is beyond the scope of this article. Suffice it to say that neither the governments chose to abolish contract labour in various establishments, nor did the advisory boards, constituted both at the state and central levels, have enough powers and efficacy to ensure the same. The fatal blow, however, was struck by the judiciary in Steel Authority of India Limited and others versus National Waterfront Workers Union and others, AIR 2001 SC 3527. This judgment by a 7-judge bench held that even if contract workers had been working for decades against posts where contract labour had already been abolished, they would not get absorbed. In fact, they would all lose their jobs when the establishment carried out proper recruitment of eligible candidates through the front door. The workers were given a clear signal: don't come to the courts, there is no hope here. Of course, this does not mean that there have not been any victories for contract labour in the courts. A notable example was the epic struggle in both the courts and on the streets by the Kachra Vahatuk Shramik Sangh that got regularization of various batches of contractual Safai Karmis or sanitation workers working for decades in the Brihan Mumbai Municipal Corporation. Today, even in large industrial establishments, not even 10% of the workforce is permanent. For instance, at the Bhilai steel plant in Chhattisgarh, where there were 96,000 permanent workers in the 1960s, there are now only around 12,000 permanent workers. Meanwhile, the same plant employs more than 50,000 contract workers who earn a fraction of the wages of a permanent worker. Contractualization, due to the precarious nature of employment, has many serious implications. First, it makes unionization virtually impossible. Usually, even before a union can be formally registered, the leaders, if not the entire batch of workers, can easily be fired. Second, these workers possess little documentation even after decades of work. No appointment letters, gate passes, salary slips, and so on, making legal recourse very difficult. These workers are also given the most hazardous and back-breaking of tasks with the longest hours, with permanent employees generally overseeing their work as supervisors. Third, the wages are pitifully low, sometimes even below the notified minimum wage. Today, 83% of the working class falls outside the fold of organized industrial labor, and 93% is non-formal, that is, has no formal contract. The dismal wage levels of the working class have been starkly described in a recent ILO report. Titled Wages and Minimum Wages in the Time of COVID-19, the report says that the real wage growth in India was one of the lowest in Asia. India's real wage grew by a paltry 2.8% in 2015, 2.6% in 2016, and 2.5% in 2017, while it remained flat in 2018. Real wage growth. Even among its immediate neighbors, such as Pakistan, Sri Lanka, China, and Nepal, India's real wage growth fared badly. Pakistan's wage grew by 8.9% in 2015 and by 4% each year for the next 3 years. Vietnam's grew between 3.7% and 12.4%, while China's grew by 5.5 to 7% each year between 2015 and 2018. Even before COVID-19, in 2018, the report claimed that in purchasing power parity terms, India's gross monthly wage of $215 was the third lowest after Bangladesh and Solomon Islands among the 30 countries of the Asia-Pacific region. A large proportion of migrant workers returned to the cities after the pandemic had passed as agriculture could not support them and rural wages had also declined. According to the ILO, informal workers saw a 22.6% fall in wages post-pandemic, even as formal sector employees had their salaries cut by 3.6% on an average. Over the years, different sections of the working classes, construction workers, domestic workers, hawkers, home-based workers, Ola Uber drivers, delivery workers, app-based service workers, have been trying to organize within the special circumstances of their employment. These categories do not conform to the working norms of a regular factory worker since they have A. shifting sites of work, B. multiple or shifting employers, and C. fragmented wages which may or may not add up to a minimum wage. While there is a lack of government regulation over employers, in some cases legal fictions are perpetuated, like app-based workers being called partners. The entire responsibility of the rural health system rests on the shoulders of Asha and Anganwadi workers, who are deemed volunteers. They are agitating to be considered as workers with all the concomitant benefits and protection. Some workers, like construction workers, domestic workers, hawkers, and gig workers, have even managed to lobby with the union or state governments to get special laws enacted for their protection and rights. It is paradoxical that the proposed Occupational Safety, Health and Working Conditions Code 2020, which Parliament hastily passed with barely any debate and which is yet to be notified, proposes to repeal many specific enactments such as the Plantations Labour Act 1951, the Mines Act 1952, the Working Journalists Act 1958, the Motor Transport Workers Act 1961, the Beedi and Cigar Workers Act 1966, the Sales Promotion Employees Act 1976, the Cine Workers and Cinema Theatre Workers Act 1981, the Dock Workers Act 1986, and the Building and Other Construction Workers Act 1996. The new labour codes. The implications of this are enormous for each category of workers. If we take just one such act, the Construction Workers Act, the code has nothing to replace the Act's scheme of registering and providing identity to workers and to grant some social security benefits using the 1% cess levied on construction activity as the source of funds. The proposed code even does away with the Factories Act without incorporating the protective provisions added to it after the terrible corporate crime of the Bhopal gas tragedy, which, incidentally, marked its 40th anniversary on December 3rd, 2024. The code also intends to repeal the Contract Labour Regulation and Abolition Act 1970, thus changing the status of abolition of contract labour from the extremely difficult to the impossible. In fact, by making unionization more difficult and by proposing fixed-term contracts, the new labour codes are making sure that the permanent worker stands to be abolished. Another extremely problematic aspect of recent lawmaking are the new debt recovery, insolvency, and bankruptcy laws. While the old Companies Act 1956 had provisions for winding up and liquidating companies and the recovery of debts by creditors, it recognized that the dues of workers stood on an altogether different footing from such debts. Provident Fund, PF, and gratuity were supposed to be non-negotiable and protected dues of workers. In fact, PF was the first charge on an employer's assets. Thus, Section 529A of the Companies Act 1956 or the comparable Section 326 of the Companies Act 2013 clearly classifies workers' dues as overriding preferential dues. However, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 and the Insolvency and Bankruptcy Code are totally focused on recovery of debts by banks and do not give any preferential place, either statutorily or even procedurally, to workers' dues. While debts to banks may run into crores and the dues to workers are in lakhs, there is an enormous difference in implication, because for workers, getting or not getting the dues is the difference between life and death for their families. Getting dues proportionately, or pari passu, as the legal maxim goes, would be a grave miscarriage of justice indeed. Despite these enormous obstacles, the working class does not stop fighting. Be it Anganwadi workers pouring into Mumbai's Azad Maidan to demand better wages, the workers of the Samsung factory in Chennai insisting that their union be recognized, the tea estate workers of West Bengal demanding minimum wages, or the workers of Maruti Suzuki demanding reinstatement after 12 years of incarceration. Even if they are ignored by the media and the powers that be, they are very much there, everywhere, invisible like the dust, and just waiting for a storm to enter our eyes. The long road to uncertainty. Contract workers are not entitled to housing or medical benefits or even subsidized food in the canteen as their regular counterparts are. Often, these workers are migrants from marginalized backgrounds. This renders them even more vulnerable. We saw what this meant on our television screens a mere week into the COVID-19 lockdown. The terrible sight of over 1 crore hungry and desperate migrant workers returning home on foot across the country.
Sudha Bharadwaj is a trade unionist and human rights lawyer. Having spent more than 3 decades in Chhattisgarh, she now lives in Mumbai as an under trial in the Bhima Koregaon case.
This is Frontline on Air. Major stories on the go.